Hello, Twitter sphere. I wanted to take this opportunity, and YouTubers, by the way, I wanted to take the opportunity. Hadn't planned on this particular topic that I'm going to talk about, but uh, it was brought out on Twitter that the appeals case on GA-38, which is if you remember, it is the case against the mask mandate in the state of Texas. Basically, the background history, the district court in Texas ruled and had blocked the state of Texas from enforcing GA-38 because it violated several different federal acts like the ADA and I don't remember what the other ones were. And a violation of Section 504 of the Rehabilitation Act and the American Rescue Plan. Well, the case they appealed it. Paxton appealed it, and it went to the Fifth Circuit Courts, and it had been sitting there for so long. Nothing had happened with it for a while. Until yesterday, when the Fifth Circuit Court of Appeals ruled that the plaintiffs in the case did not have standing. Now, I was hesitant to look at this and go through it because I don't want to go through something knowing full well that maybe the court was right in its ruling. But after reading the ruling, I decided I wanted to comment on it because I do have some comments on some points that I have my doubts as to whether or not the Fifth Circuit was correct in their judgment. So I wanted to go through the opinion or the ruling rather, and talk about it. Maybe I don't want to go at great length, but I do want to get into it. It may take a little bit of time, but I wanted to cover the basis as best I could. The ruling itself was issued yesterday, as you can see on the screen. It was filed yesterday, and it was seven families of disabled students that had filed this lawsuit against originally Governor Abbott and Ken Paxton. Well, after a while, after a certain amount of time, these plaintiffs decided to drop the lawsuit against the governor himself who in actuality was enforcing the ruling was in fact Ken Paxton. He began suing all these school districts for enforcing mask mandates during the pandemic. And to say he got carried away is an understatement because there was just a ridiculous amount of letters and lawsuits that were thrown at school districts statewide. And so basically, that's where this lawsuit arose from. I wanted to sit down. I want to go ahead and go through it really quick. The first few pages, it talks about, outlines the case, the case argument, talks about what GA-38 is, which is basically, it was an executive order that said that no governmental entity, including a school district or a government official, may require any person to wear a mask or face covering or mandate another person to wear a face covering, and that GA-38 has the force and effect of law. It also explains who the plaintiffs are, that there were children with disabilities attending Texas public schools, that the lawsuit was filed August 17th, and in the federal district court challenging GA-38 and the related public health guidance from the Texas Education Agency, the TEA. The original it talks about the original complaint had 14 plaintiffs who were students with disabilities. Named the defendants, as I said before, Governor Abbott, TEA Commissioner Mike Morath, and Ken Paxton. The original complaint had three claims: violation of American Disabilities Act (ADA) against Abbott and Morath, in their official capacities, violation of Section 504 of the Rehabilitation Act, and federal preemption under the American Rescue Plan against all defendants, and that the plaintiffs wanted declaratory and injunctive relief. Okay, and it goes through here, and he starts talking about Article 3 jurisdiction and the fact that basically the plaintiffs were not able to present an injury sufficient to satisfy Article 3. It says to establish such an injury, plaintiffs must show, they suffered an invasion of a legally protected interest that is concrete and particularized, and actual or imminent, not conjectural or hypothetical. Okay, it says, and he refers to a case Spokeo Inc. versus Robbins. Plaintiffs haven't carried that burden because here the injury that they're alleging is not a cognizable injury in fact, and they may not relabel their injury as something it's not. And he's saying that because of the fact that he's saying that they're claiming that the risk of infection is an injury, and since they're assuming there was no infection or no risk, they could not call the risk a damage. Now, in the following sections, he talks about, he goes in further detail about this, talking about the risk, talking about, if we look here, COVID-19, and the plaintiffs establishing COVID-19 infections as a certain impending in schools without mask mandates, but not in schools mandating masks. And he talks about that some of the statistics that they pulled show that the ratios or the differences in infection rates are basically the same. That there was no difference to show with certainty that masks were preventing infections of COVID-19. Okay. As we keep going into here, he starts talking about that was taken to district court. They entered the permanent injunction, and says even the district court, which entered a permanent injunction against enforcement of the executive order, could not say that GA-38 creates a impending harm or substantial risk or harm to plaintiffs. He's saying the district court could not even say that or confirm it. And the paragraph says, third, plaintiffs misunderstand the relevant legal question. What matters for Article 13 is whether plaintiffs suffered an invasion of a legally protected interest. Neither the ADA nor Section 504 creates a legally protected interest in equality simpliciter. Rather, those statutes legally protect reasonable access to covered facilities and benefits, as they required covered entities to facilitate such access by way of reasonable accommodations. So ADA plaintiffs are not necessarily injured every time their method of access differs from that of their non-disabled peers. They're injured when they are denied the reasonable access, okay? This is what he's saying. So, and this is part of the argument that they're making is that these plaintiffs did not ask for these reasonable requests of access. In this case, they should have asked for the masks to be implemented. And that was part of the issue that the court had. Well, we keep looking here. It keeps talking about ADA. He said there's no basis in the third paragraph for plaintiffs' claim that GA-38 denies them something the ADA guarantees, namely the right to individualized case-by-case decision-making. It's true that the ADA entitles disabled students who inform their school of a disability to an individualized assessment of their needs is also irrelevant because the record contains no evidence that any of these plaintiffs ever requested an accommodation from anyone. There's where they're talking about that. Because he didn't ask it, that's why this creates this issue in the case. Now, if we look at the body of the document, I'm going to go back one more page. You can look at it as well with me and see. He doesn't go into, on those 2 pages, anything about Section 504. He keeps talking about the ADA in the following page, and he goes to say the record supplies no reason to think any student would have been denied such case-by-case determination if the plaintiffs, in fact, requested them. Nor does GA-38 in any way prevent case-by-case decision-making. It simply emanates one option, a mask mandate and retains all others. Now, the issue that I have here with this is, plain for a fact, is that when we were in the middle of the actual pandemic, because we're still in it, but we've come a long way. When we were in the middle of this pandemic, there was only really three viable options to combat this virus, COVID-19. One was mask wearing, and the CDC and the World Health Organization, all these health agencies, validated that yes, masks, in fact, did help prevent the spread to a certain extent of COVID-19. Other option was social distancing, and that was implemented as well. Another option, which there's really, and I can speak for myself because I work for a school, there's really no way to implement this third option, which is plexiglass. To implement plexiglass, you would have to put plexiglass around every student desk. That is cost, what's the expression I'm looking for? It's not cost benefit to the schools to do that. The last option, and this is what was implemented at the beginning, was virtual learning. Virtual learning, number one, for a lot of the schools, and I'm going to be honest, and I speak this because I have a son who is in school, in high school, and I saw what he went through during the virtual time frame. They were all in virtual classes. Unfortunately, the instructors, the teachers, the schools, the administration, they did not have the knowledge, I guess, or the insight on how to really better apply the method of virtual learning. The reason I say this is because virtual learning does not mean that your student has to sit behind a computer for 12, 14 hours nonstop just to get a day's worth of work done. There has to be a limit. I mean, because a lot of the students, and my son told me, and other students that I've dealt with, myself have said, well, we're in class, the teacher talks to us, take notes, they give us a video to watch, or they give us a passage to read, and we have to sit down and jot notes afterward. And that's on top of, and this is, he says, you gotta keep in mind, this is not just one class. There's 7 classes that you gotta deal with, and when you got 7 classes, that's a lot of work to do, aside from being inside the virtual classroom during school hours. And it kind of makes sense a little bit. Now, I'm not gonna argue that point or discuss that point any further. That's just an observation. So I think if the instructors would have made better use of the method of virtual learning, maybe it would have been more beneficial to the students during that time frame. Now, that's beside the point. The issue here now is that in order to do virtual funding or virtual classes, the state needed to give the schools the funding, and they didn't. They cut the funding out. So it basically left virtual learning out of the question. So you eliminate virtual learning, you eliminate mask. What do you have left? Social distancing and plexiglass. You can only do so much with those 2 options. And that's the point that I'm getting at. Because this executive order didn't do much in that manner. So that's where I have the issue with what he's saying here about I was reading it out. I lost my place here. In this first paragraph. Now, in the second paragraph, he says, here all agree plaintiffs have physical access to their classrooms. All agree 7 schools take a prolonged approach to COVID-19. All agree plaintiffs, their classmates, and their teachers are welcome to wear masks, and those around them to wear masks. All agree plaintiffs presented zero evidence that anyone, let alone individuals working constantly with a disabled child, would refuse to request to wear a mask. The issue here was not whether or not the schools were making it optional. There was reports in the news at one time that schools were doing the optional mask optional usage, and still there were reports that the Attorney General was threatening to sue these schools because the rumors that the students were using masks. So there was no distinction between optional or obligatory. Okay, we keep looking at here on the next page. It talks about how heavy the burden is the plaintiffs have to show by preponderance of the evidence that the Attorney General's enforcement of GA caused their injury. It's okay. But because GA-38 doesn't regulate the plaintiffs, it regulates the school districts. Plaintiffs must make an additional showing. Plaintiffs must show the Attorney General's enforcement of GA-38 caused the school district to drop their mask mandates. There is numerous evidence that this is a fact. All the letters that the Attorney General sent out, all the lawsuits that he filed against these school districts, are clear evidence that he's enforcing. This is the evidence that these plaintiffs, they should have showed if they hadn't showed it, but I would think they would have because it was addressed. Evident is clear that the Attorney General was enforcing by lawsuit. The evidence is there. So this particular burden is met as far as I can tell. And it is also plaintiffs' increased injuries resulted from the school district's elimination of mask mandates. Well, the increased risk is there. How many schools had COVID infections toward the beginning of this year, the end of last year? Multitude of schools had COVID infections. It was all in the news. There's news reports, and these news reports are evidence to that respect. So these 2 points, these 2 points are the plaintiffs can show them. Now the next paragraph says that the plaintiffs cannot come close to that showing. Obviously, here, if based on what I've just mentioned now, the lawsuits, the news reports, the letters and all that evidence shows it. Yet the Fifth Circuit says that it's not even close. This is one of the main issues that I have with this ruling is that I find that the Fifth Circuit is probably in error. Is the fact that they're saying that evidence doesn't even bring it close to proving it. I mean, that evidence is irrefutable. That evidence is solid. Okay? And he said on the first point, it's undisputed the Attorney General's enforcement activity did not cause 5 of the 7 plaintiffs' schools to eliminate their masking requirements. As parties stipulated at the time of trial, those schools maintained their mask mandates despite the governor's issuance of GA-38, despite receiving threatening letters from the Attorney General, and despite the Attorney General actually suing some school districts. So with at least respect to 5 of the plaintiffs' schools, plaintiffs cannot establish the first link in the causal chain. So he's saying basically that because these schools ignored the Attorney General, there's no way to prove there was a threat. And I guess that makes sense. To that point. But that doesn't discount the fact that there is evidence to prove that Ken Paxton was in fact enforcing this mandate using lawsuits. Now it says in the last paragraph, it says even though the Attorney General's enforcement caused plaintiffs' schools to not mandate masks, plaintiffs could not trace their increased risk injuries back to the executive order. I think they could have because of the fact that that it was it was made known by the CDC that the lack of masks would increase the risk of COVID, and the statistics that we had during that time frame, the COVID rate was like increasing exponentially, especially amongst the children. So there is statistical proof to corroborate that. Okay, the next page, real quick, he talks about that the entirety of the district court's finding on the point was that the use of masks may decrease the risk of COVID infection in group setting. That finding fails to support the plaintiff's contention that mask mandates are the only way they can adequately reduce the risks of COVID-19. It says nothing about allowing but not requiring masks. It says nothing about mask relative efficacy vis-a-vis other mitigation measures. Apparently, the Fifth Circuit did not look into the CDC's guidelines or the CDC's statistics on that. Otherwise, what they're saying here goes against what the CDC is saying. So I'm going to leave that at that. We go to the next page. I'm going to go back to the screen so you can see where I'm at now. He talks about the plaintiffs could not meet their burden on injury. In fact, the traceability, they were not able to show their injuries are likely redressable by a favorable decision. I think that is a 50-50 on that, because if they would have blocked the mandate, schools would have been free to implement masks, and that implementation may have decreased the numbers. We'll never know, because unfortunately, number one, a lot of the schools came down on masks. Number one. Number two, we're at a point now toward the end of the pandemic where everything is coming back to an absolute normal. Hopefully, we're not at that rate yet or at that position yet. Don't get me wrong, but we're hopefully going in that direction if we don't get stumbled by the recent development with the monkeypox. But that's a whole different ball game, and I'm not going to get into. We keep reading here. They keep talking about that the plaintiffs chose to sue the Attorney General. And he goes, well, what does the Attorney General have to do with plaintiffs' increased risk for COVID? Nothing. That's wrong. What does he have to do with their increased risk? What he has to do is that he's suing school districts. He's forcing school districts to drop mask mandates in fear of being sued. Dropping the mask mandates, that in one way or another will increase your risks of transmission. And that I can attest from experience. I'm not going to say how or why, but I can tell you, you drop the mask mandates, if you're not careful, your infection rate can go up. Okay. So we keep reading here. I'm going to jump a couple pages. And we see this. This is the dissenting judge. And because keep in mind, this is a panel of judges that are making this decision. They're making this decision, and some of these judges will dissent, meaning they're going to disagree. So this is a dissenting judge right here. He says the parents of, I'm going to read this really quick, just bits and pieces. I'm not going to go through the entire thing for lack of time. He says the parents of 7 severely disabled children, highly susceptible to contracting COVID, brought this straightforward disability discrimination lawsuit against the defendant, appellant, Texas Attorney General Ken Paxton. Let me read on. It says that here, let me see. Based on GA-38 and Paxton enforcement, the plaintiffs contend that they are effectively excluded from in-school classes because of their disabilities and the dire consequences they face if they contract COVID-19. More specifically, based on unchallenged evidence that established without some type of mask mandate, they cannot attend classes during the pandemic, and that they are unfairly deprived of the valuable benefit of attending school in violation of Section 504 in the ADA. Because the district court found uncontradicted evidence that the defendant's enforcement of GA-38 was the only impediment to a school district granting a modification required by Section 504 and Title II to allow plaintiffs to attend school safely, the injunction was appropriate. The majority found, he's talking about the majority in the appeals court, found the plaintiffs had no standing based in part on their erroneous assumption that plaintiffs had brought a simple fear of COVID-19 case rather than the disability discrimination case that they pled and tried. This dissenting judge even says this. He says, in my view, plaintiffs proved each element of standing, and I strongly disagree with the majority's contrary conclusion. Further, I conclude that the district court correctly issued the injunction against the defendant's enforcement of GA-38. O-M-frickin-G. What is he saying? This dissenting judge is basically confirming what I said at the beginning, that they did have standing, and that the district court correctly issued the injunction against the defendant's enforcement. Let's read on and see exactly what he says. I'm not gonna read every sentence line for line. He gives background history here in this page, saying that Greg Abbott issued GA-38 on July 29th of last year. This is basically a year ago to the day almost. It'll be a year ago this Friday when the anniversary of GA-38, and look where we are with this ruling. It's barely going to be a year. Amazingly. This is after Governor Abbott issued GA-38, Paxton undertook a campaign against the school districts, threatening to enforce the order. His office sent at least 98 letters. 98 letters. Oh, my boy. To school districts, to different ISDs. He filed 15 lawsuits. Wow, 15 lawsuits. Give me a second here. I'm trying to set up my screen. 15 lawsuits. And made public statements on Twitter expressing his willingness to continue litigating against non-compliant school districts. Wow. He's basically telling the whole story here. Okay, now we go to the next page and we keep reading down. We'll see that it said that after a bench trial, the district court concluded as relevant here that GA-38 is preempted to the extent that it interferes with local school districts' ability to satisfy their obligations under the ADA and Section 504 and their implementing regulations. The court recognized that the ADA and Section 504 impose an affirmative obligation on public entities to make reasonable modifications in their policies, practices, and procedures when necessary to avoid discrimination on the basis of disability unless they can show that doing so would fundamentally alter the nature of the service, program, or activity. The court found that GA-38 prohibits the use of mask mandates, including targeted and limited ones, even when a school district determines that requiring masks is a reasonable modification necessary to enable a student with disabilities to have equal access to a safe and integrated in-person learning environment. The judge says, on the outset, I emphasize that this case was tried to the bench and the district court based on essentially uncontradicted evidence entered detailed findings of fact. Plaintiffs produced evidence from their personal physicians attesting to plaintiffs' disabilities and giving their strong opinions that because of these disabilities, they should not attend classes where students and staff were not wearing masks. They testified that when the action was filed and tried, the plaintiffs were not eligible for vaccinations against COVID-19. That's an important thing, too. The other option that came out shortly thereafter was vaccines. Those vaccines were not available at the time this lawsuit was filed. So we have to keep that in mind. He says that in any event, no option except requiring staff and students in contact with them to wear masks would give plaintiffs adequate protection from COVID-19. Given the dire consequences plaintiffs could suffer. Plaintiffs also produced evidence that the schools they attended had mask mandates in place until GA-38 was issued, and the defendant began aggressively threatening the school district with lawsuits and fines if they required students and staff to wear masks. I said this earlier. I said a lot of the misnomers are that at the time there was school districts that were doing the mandatory mask mandates, irregardless of the executive order, but a lot of them a lot of them dropped their mask orders because they were threatened by the school districts. And here the judge is concurring with what I said earlier. It says the majority holds that plaintiffs failed to establish standing. Judge Oldham, the writing judge, concluded that plaintiffs established none of the elements in standing: injury, traceability, and redressability. Judge Willett agreed their injury is not redressable, in effect finding that plaintiffs should have sued the ISDs, not Paxton. This judge says, in my view, plaintiffs alleged and proved each element of standing. I think they did, honestly, because they proved that, and because they had the backing of the CDC, they proved that in fact with masks they would have had some sort of protection against COVID, and that there was a substantial risk. Okay, we keep going through here to read and see. He talks about the plaintiffs in the case, MP and ES, are enrolled in schools that rescinded their mask requirements in response to GA-38, although at the time of filing their ISDs had not rescinded their mask mandates. Okay, he says the remaining 5 plaintiffs of those 7, injuries were imminent. Their injuries were certainly impending. That is, that there was a substantial risk that the harm would occur. Probably because COVID-19 the infection rate was ever increasing at the time in those schools. Okay? Plaintiffs had sufficiently demonstrated a substantial risk of injury. All these students are suffering or at substantial risk of suffering an injury sufficient to confer standing. If they choose in-person school, they are compelled to accept a far higher risk to their health than is required of students without disabilities. These students need not prove that access to school is impossible. It is enough that GA-38 removes the tool the record shows that would afford them the opportunity to participate in in-person schooling equal to that enjoyed by students without disabilities. Basically, GA-38 removes the one tool that would have adequately protected them, which was masks. It says, in short, plaintiffs have satisfied the Article 3's injury requirement. The discriminatory denial of equal access to education is a concrete harm, is particularized to each plaintiff, and is actually materialized. So he's basically saying, or concurring with what I said this whole entire time, that they do have standing, and that they are in risk. Okay, he says, Paxton, the Attorney General, did not trace redressability in his brief to this court. For good reason. Plaintiffs clearly established traceability. Under this element, plaintiffs must show a causal connection between the injury and the conduct complained of. The injury has to be fairly traceable to the challenge act of the defendant, which is done here from what the judge is saying, and what I agree. He says, not the result of the independent action of some third party, not before the court. But Article 3 requires only de facto causation. It says, at trials, plaintiffs introduce uncontroverted evidence that establishes traceability for at least one plaintiff, which is all that is required for standing. Specifically, MP attends school in Fort Bend ISD, which dropped its mask mandate by the time the trial occurred. Plaintiffs submitted an affidavit by Danetta Williams, an elected member of the Board of Trustees of Fort Bend ISD, who attested that the mask mandate would remain in place, would have remained in place but for Paxton's enforcement of GA-38. This evidence is sufficient to establish that Paxton's enforcement efforts were the de facto cause of MP's injury. Proven. And the evidence that Ken Paxton has, the letters, everything he posted on Twitter, the 15 lawsuits that he filed, that is all concrete evidence that would prove the injury, that would prove that, in fact, Paxton is enforcing this. He is threatening these schools, and he was the de facto cause that increased the certain risk of COVID at the time. Okay, to establish the final, let's go to section C. To establish the final element of standing redressability, plaintiffs must show that it is likely opposed to merely speculative, that is, a favorable decision will redress their injury. This requirement is met when a favorable decision will relieve a discrete injury to the plaintiff. So they need not show that a favorable decision will relieve their every injury. Plaintiffs satisfied this requirement. The judge is even saying that this requirement he finds that they satisfied it. Because the redressability here would be implement the mask to reduce the transmission. Plain and simple. This page, they talk about that that the plaintiff sued the Attorney General, who was the official who was actively enforcing GA, to get the relief they required. They did not rely on speculation that the school district would impose mandates if Paxton was enjoined. Instead, plaintiffs submitted the evidence establishing at least one ISD would immediately reinstate its mask mandate if Paxton is enjoined. In particular, plaintiffs rely on the affidavit by Williams, who attests that if Paxton stops enforcing GA-38 or there's an order barring enforcement, the mask mandate enforcement ISD would immediately go back into effect. It says the unchallenged evidence also reflected that the districts had mask mandates in place when GA-38 was issued. The defendant produced no evidence that any of the school districts had ever had opposition to the mask mandates in place. It was only after GA-38 was issued and Paxton's enforcement activity began that the school districts began yielding to those threats and began lifting their mandates. If this court affirms the district court's injunction and holds that Section 504 and Title II required that these districts be allowed to exercise their discretion as to each individual plaintiff and provide appropriate modification, it says it will comply with the law by imposing some type of mask mandate. GA-38 does not permit the school districts to do this. As the Supreme Court explained in Department of Commerce versus New York, plaintiffs can properly rely on the predictable effect of government action on the decisions of third parties as an element of their standing. There's a federal precedent here that basically supports this lawsuit. And unfortunately, the appeals court ignored it. They ignored the precedent. As I read this, it leads me to believe that this decision was not totally arrived at a legal standpoint. I mean, as he said, the majority rule, but the judges that dissented, they've basically proved their case. So, I mean, it's clear and evident in this ruling. Okay, we keep going here. It says the district court recognized that ISDs could refuse to impose mask mandates if such mandates fundamentally alter the nature of school programs. But as the district court correctly noted, Paxton failed to present any evidence that would support a claim that mask requirements fundamentally altered the educational programs of the local school districts. So basically here, Attorney General Ken Paxton should have presented some proof saying, okay, these mask mandates would change the basically the educational programs of the school. He never presented any of this evidence to the court. As he failed to do so, he should not have won this decision from what the dissenting judge is saying. Okay? But he utterly failed to do so. In fact, during the proceedings below, Paxton submitted a single piece of evidence, a massive raw data showing COVID-19 infection numbers in Texas public schools. He said he did not even provide an expert opinion to assist the district court or this court in interpreting the data. Paxton's decision did not produce evidence that should be fatal. No, Paxton's decision not to produce evidence should be fatal to his arguments. Most definitely. If you can't prove your case, you have no case. And I think that's very detrimental to Paxton's case. The fact that the Fifth Circuit ruled in his favor, probably the majority were conservative. That's what this is all leading me to believe at this point. Okay, it says here, he says, in sum, the disability discrimination plaintiff suffered a sufficient injury. Paxton enforcement was the de facto cause of this discrimination, and an injunction would remedy the injury. For these reasons, I am satisfied that the plaintiffs established each element of standing. Okay, he says, and here they're talking about this. He goes here. However, I agree with Paxton that the district court's injunction is overbroad. An injunction should be no more burdensome to the defendant than necessary to provide the complete relief to the plaintiffs. Plaintiffs' injuries would be remedied by a narrow injunction that prohibits Paxton from enforcing GA against the 7 ISDs. Now he's saying basically, okay, in hindsight, he's saying the court should have made a more narrow ruling. Just those 7 school districts. They didn't. And he goes, I agree with the district attorney on that. He says the injunction should have been limited accordingly. I think that could have been a comparable solution, in my opinion. But given the nature of the pandemic and the nature of the situation at the time, I think it suited the district court to make it statewide. And I can understand that. I think if I was a judge and seeing the pandemic the way it was at the time, seeing the situation, I may have been prompted to issue the injunction on a statewide level. I don't know if that would have been correct, but I think it would have been the wise thing to do given the situation with the ongoing pandemic. He says, for the foregoing reasons, I would affirm the district court's decision. However, because the injunction is overbroad, I would vacate the injunction and remand it so that the district court can modify the injunction to bar Paxton from enforcing GA-38 against the 7 ISDs, but limited to the extent that it precludes school districts the authority to grant a limited mask mandate to allow the plaintiffs to attend school safely. Therefore, for these reasons, I respectfully dissent. And that's basically the case in a nutshell. The Fifth Circuit Appeals ruled in favor of Paxton, saying he had no standing. Based on the evidence, based on what the plaintiffs presented, based on statistics, based on the dissenting judge, I want to say, in my opinion, that the Fifth Circuit Court of Appeals erroneously ruled on this lawsuit. Why? Because based on the dissenting judge saying these guys met the requirements, based on the fact that he says Attorney General Ken Paxton did not present any evidence to the contrary. Now, ask yourself, you've got these plaintiffs, you've got the Attorney General. The Attorney General presents no evidence whatsoever, except a bunch of raw data that not even the court can interpret. How does the Fifth Circuit Court of Appeals come to this judgment? It makes no sense. It honestly makes no sense whatsoever. I hope, and I sincerely hope, that these plaintiffs do not decide to give up on this case. I hope that they would bring it to the U.S. Supreme Court and then basically reinforce their arguments, because they've got a good solid argument with the dissenting judge, and that may help their case. But needless to say, I think it needs to go forward to the Supreme Court, and I hope that it does. I hope that it doesn't stay here at the appeals level. Now the court and the appeal said, okay, we want this case dismissed, and we want remanded back to the district court for them to dismiss without prejudice. I would suggest to these plaintiffs, if they're going to appeal it, they need to do it quickly. Because once the case goes back down to the district court, if they dismiss it, you're not going to be able to take it to the Supreme Court. Plain and simple. Well, that was my opinion on this. When I saw it, I was not too, to be honest with you, I was not too happy about it. Now, keep in mind, when situation when this lawsuit was filed versus the situation now is totally different. I would understand if the plaintiffs decide not to go forward because the issue would be technically moot at this point. But if they chose to go forward, I think it would be a good idea to basically do it on principle. So this was my take. This was my opinion on this case. I didn't mean to take this long, but I wanted to go through it, and I wanted to voice my concerns and my opinions on certain aspects in the lawsuit. And I hope that I did that. I hope this makes this a little more interesting, and we have to wait and see what happens going forward with the plaintiffs if they decide to appeal. And if they do, and it goes to the Supreme Court, obviously we'll be watching it. I'll be commenting on it later on. We probably won't know anything until the end of the year, because that's when they start hearing more cases in the term, and then we'll probably see a ruling maybe spring of next year. I don't know, or summer. Well, have a good evening, and I originally was going to do a second video on a series that I started yesterday. I think I will leave that for tomorrow, and we'll see you then. If something else comes up between now and then, of course, obviously I will live tweet, try to be brief about it, and not long-winded like I was today. Thank you. Have a good night, and enjoy your evening.